Call the case of 125-328, State of Kansas versus Wash. Counsel, please come forward.
Laura Stratton, representing Devonte Wash. I request 3 minutes of rebuttal.
3 minutes is granted. Thank you.
My client, Devonte Wash, was convicted of the capital murder of his girlfriend, Ms. Ashley Harlan. We have advanced 5 assignments of error. We believe they all have merit, but we believe the arguments that would most benefit, the issues that would most benefit from argument are our issues 1 and 2. They are both essentially prosecutorial misconduct, and they dovetail together. Particularly, I think issue 2, I believe there's some confusion about what is in dispute. So issue 2 is about how, after extensive litigation, the trial court held that the state could not elicit or argue that these 2 particular bullet casings were a match. That is to say, they were fired from the same gun. It's important to put these bullet casings in context about why they were so important to the case. So the state's case against Mr. Wash was very weak. He had an alibi. They had no murder weapon, no eyewitness, no confession. DNA and fingerprints were not probative because they were in a relationship. There was no cell phone data putting him at the location. So this bullet casing, the 2 bullet casings, which the state purported came from the same gun, are the only thing that put Mr. Wash at the crime scene. That's why they were so important to the state. Additionally, there was a lot of evidence the state couldn't explain. There was the semen of 3 different men found in Ms. Harlan's mouth, in her navel and vagina. There was a baggie in her hand of the kind commonly used for drugs. There was also drugs in the house. Neither Mr. Wash nor Ms. Harlan did drugs. He was applying for national security clearance at the time. There were animal hairs in her armpit. Neither she nor Mr. Wash had any animals. There were recent fingerprints in the bathroom that did not match Mr. Wash. There was a footprint going out the back door, which was open, which did not match Mr. Wash. There were defensive wounds on Ms. Harlan, which Mr. Wash did not have any. There's a receipt for cigarettes that had just been purchased. Neither of them smoked cigarettes. The cigarettes weren't there. None of this matched Mr. Wash.
Was there any evidence of identity of the 3rd set of DNA found on her navel?
There were people who were excluded,
Right.
but no one matched.
Okay.
Let me ask you about, so while we're trying to stack up the occurrences, the first one was with the grandmother. And I'm concerned about preservation on that issue because that was the first time the prosecutor said, did you know that there was a match on these cases? And there was no objection until the end of the direct examination. Now, I've looked at that a lot of ways, trying to figure out what's reasonable. It was 34, the objection came 34 lines in the transcript after the objectionable statement. It was on the, just the top of the next page of the transcript. But yet it wasn't done, immediately like the other objections were later in the trial. I'm trying to figure out how to say that's preserved. If you say, well, it came 1 page in the transcript after the objectionable statement, well, why not 2 pages? Why not 3 pages? What's your take on why this is preserved?
It's preserved because the court was able to cure it in the way it cured all the other objectionable statements, which is to warn the jury, you cannot say that the 2 bullet casings are a match. So Miss Earline was still on the stand. They were still on the same subject. It wasn't as if they'd moved on to something else. So the judge still could have cured it for the jury by issuing an admonishment. which is the basis of the preservation rule.
I'm trying to, and what worries me about this is the precedent it sets. You know, when you come up in the next case and you say, well, okay, we didn't object to it, you know, for 15 minutes, but when we did object to it, the court took an effort to cure it. So therefore it's preserved. That sort of blows all of the case law that we have out there on this subject. And so again, I mean, if that's your best argument, that's fine. And I don't mean to take up a bunch of time here, but that's one thing that's worrying me about this, that particular incident.
I understand, yes. And I there might be a line drawing problem. How many pages beyond, you know, the objectionable statement can you go? I agree there might be a line drawing problem. I would like to, again, discuss issue 2 and what it is that we're arguing about, because the state's argument is that what the trial court meant was that we couldn't elicit from our expert that these 2 bullets were a match. We couldn't elicit it from a late witness that these 2 bullets were a match, but we could argue the inference before the jury. The problem is that the state advanced this argument before the trial court, and the trial court, interpreting its own order, said, no, you may not do that. So what the state is arguing before this court has already been decided. The state did not appeal that issue, did not cross appeal. So it's difficult to understand why we're arguing about that. It seems as if we should just go on to prejudice. And to answer the question about prejudice, I feel like we should ask ourselves, why did the state so persistently and willfully disobey the court order? And again, it's because that was their main case. They needed it so badly. And as I mentioned, issue 1 and 2 dovetail together because the bullet casing, all it did was put Mr. Wash at the scene. It didn't take care of all these other holes that needed plugging, namely the semen and the cigarettes and the fingerprints and the footprints and all these things. And that's where the other prosecutorial error comes in, which is the we know statements. We know exactly where Mr. Wash was for this entire 2-day period. We know it was premeditated. We know the alibis of the alternative suspects are airtight. We know who's credible. We know the police did a great job. And I don't mean to catch out any particular prosecutor, but this was someone with 30 years of experience. It was the elected prosecutor of Johnson County. In all likelihood, some of the jurors on the jury had voted for this person, put their trust in him to some extent. And so for him especially to get up and say, we know, that has a lot of meaning. It carried a lot of weight. And especially if I could draw the court's attention to one thing, it would be volume 77, page 119 to 120. This is the last instance of the prosecutor bringing up the same markings, that the bullets are the same, came from the same gun. He asked the jury to make the inference. Defense objects. The court says, the science does not allow you to reach the decision that they came from the same firearm. Moving on. We've litigated this. Prosecutor moves on. This is just the next page. Still discussing whether or not those 2 came from the same firearm. Second full paragraph. They don't want to talk about that. They want to argue about it. So here, you know, the court has tried admonishing, sustained the defense's objections repeatedly, has admonished the jury what it could and couldn't consider. It's tried to cure all these errors, but in the end, the prosecutor undermines it in a way that arguably is actually burden shifting because the defense doesn't have to say anything. But it's alluding to this idea that jury, trust us. We have all this information, and if we could just get it to you, you would understand. You would know what we know, which is that he's guilty. And we're just being hamstrung. It almost impugns the trial court a little bit. So I think, you know, I don't use the word deliberate flippantly either, but I think it is fair to say that this was a, you know, persistent and deliberate violation of the trial court's order. and putting its unsworn testimony before the trial court. Because if this person had gotten on the stand and had said, we know, and had been cross-examined by defense counsel, he would have been eviscerated because he doesn't know all those things. And it would have become very clear that these were not credible statements. He might think these things, he might have the opinion, but that is not what testimony is meant for.
Help me with, the trial court ruled you can talk about similarities,
Yes.
but not specifics as to where the cartridge is from a specific firearm. And here, to help me with the prejudice part here is that, yes, it appears that the prosecutor crossed the line in making argument about that. But does that really preclude, and there was admonishment, does that preclude the jury from just considering similarities?
No, the jury could consider similarities.
I know. And so why aren't they just doing that with the admonishments that were given to counsel? And I don't want to give free rein to argue whatever you want to argue. The state has that capacity. But help me here with why there's prejudice that would require a retrial here.
The prejudice comes from, again, the position that this prosecutor was in. You know, and I understand that it was a little dicey to say, well, you can say that the two bullet casings have similar characteristics, but you can't say they come from the same gun.
That's pretty clear. That was the court's, I mean, there was scientific, had a long hearing to establish that.
Yes.
I understand that.
Yes. And
So why doesn't the jury understand that with the presentation of evidence that happened, that all we can take into account are similarities, not, and even if the prosecutor crosses the line, why do we conclude that's what the jury may have done?
well, I don't think we have to. I think we conclude the state can't prove beyond a reasonable doubt that the jury didn't consider that.
I understand. Okay.
Can you really quickly help me with some measure of precision understand what's the gap between similarities and scientific certainty? I mean, for example, what were the similarities and why weren't they sufficient in the trial court's mind to enable the state to argue a same gun?
There were 1,300 pages in this record about firearms tool mark evidence, and having read it all, I still am not even conversationally fluent in firearm tool marks evidence. I can just, I trust that they, I trust the process. I don't know is the answer.
Okay, fair enough.
Are there any subjective determinations made by the experts when they issue these opinions? Judgment calls.
I don't know that I know the answer to that. I don't know if I could say. I mean, I suppose there always are some judgment calls, even for an expert, is all I could respond.
It seemed to me that in the court's ruling on the motion, and he mentioned that you know, we don't have the gun, and perhaps I'm misremembering, so that's why I'm asking you.
I mean, my reading of the court's ruling is that, you know, under Daubert, under the whole of human knowledge we have in 2025, we cannot say from the evidence before us, these two bullet casings, that they came from the same gun. I'm sure when it comes to specific, to be honest, I just don't know. I don't understand firearm tool marks evidence enough. So I won't try.
Can I ask one more real quick question?
Yeah.
Is it your position that the state's error in discussing the casings was the use of the word same as opposed to similar? The state multiple times made reference to the same markings. If the state had just said similar markings, would there be error?
No, I don't think there would have been error.
So it's that word.
It's same, and then also I think them being a match.
Okay.
Those were used interchangeably.
Okay.
Thank you.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the state of Kansas.
Can I just get out of the way, my curiosity, or more than curiosity? Can you answer the question I just posed to your opposing counsel about the precise difference between same markings or a match versus similar markings?
That question would probably be best posed to Judge Draghi, but since I'm the one at the podium, I don't see a whole lot of daylight between the two, but the state understood that Judge Draghi made a distinction between the two.
Yeah, and I'm not asking for the semantics of the words. I'm asking for an actual understanding. Like, do you understand those 1,300 pages well enough to articulate what the gap is between those two things?
I believe the gap is that the court's pretrial ruling was very, very specific. It did not hamstring the state's argument. But what the trial court said was its pretrial ruling was, quote, as to what Mr. Buttel, the state's ballistic and tool mark witness, and any other firearm tool mark examiner called to testify may say, and what such a witness may not say. And the trial court prohibited those witnesses from stating that there was a match or they.
And I'm probably not asking my question clearly enough. I'm actually interested in what was on the bullet casings. Can you articulate what was the similarity and why wasn't it sufficient to allow testimony about a match?
The similarity was, I would draw the court's attention to State's Exhibit 364. There are slides. It's a slideshow of the actual analysis conducted by the tool mark examiner. And you would be able to see side by side the microscopic photographs taken of both casings, the casing found at the scene and the casing from Mr. Wash's gun. The casing he admitted was from his gun when he was testifying. You can compare the two and you can see for yourself. And that's what the state was doing in its examination of witnesses, as well as in its closing argument. It was encouraging the jury to look at those two images.
And they had those.
And they have those. They were before the jury. The tool mark examiner testified about them and the jury had them in front of them. They had them back in the jury room and they could look at the images and they could line them up.
With that, given all that, why isn't it error to say that they're the same markings or that they're a match?
It's not error for the state to argue as much because the pretrial ruling never hamstrung. It never confined the state's argument.
Was there any admissible evidence that would support that argument?
There was, and it was all the evidence from the tool mark examiner, where he said specifically that he could testify about the different markings, the striations on the side, the firing pin.
Well, is there any difference between saying same markings, they're a match, and saying they came from the same gun? Is there any difference between those two things?
I don't believe there is.
Right, and isn't that exactly what the trial court prohibited the state from arguing?
No, the trial court never prohibited the state from arguing anything. The trial court prohibited the witness from testifying that they were a match. It didn't prohibit the state from arguing the reasonable inference from the images or that they came from the same gun. Much the same way the state argues DNA evidence or fingerprint
And you
evidence.
don't think you don't think that inference required expert testimony?
The inference came from the expert testimony of the tool mark examiner. He never said they were a match, just like DNA analysts never testify about a match.
Well, doesn't the Daubert ruling suggest that that isn't a reasonable inference?
It doesn't. The Daubert ruling prohibited the witness from testifying with a scientific certainty that they're a match. Much like DNA analysts.
Because
DNA analysts will never testify to a match.
it's not it's not a reliable or reasonable inference to be drawn from the tool marks.
That's not the pretrial ruling, and that's not the Daubert ruling. You can make an inference, you just can't make a statement with scientific certainty that they're a match. Much like DNA analysts will not testify that these two samples from a scene and from an individual are a match.
Don't tool marking experts do this regularly?
I'm sorry?
Don't tool markings experts do this regularly in our courts? They say these two casings came from the same gun. They say it all the time.
They do. Not in Judge Draghi's courtroom, but they do in other courtrooms.
Well, but back up on Judge Dragi's ruling a little bit from what you read. And he said there's new evidence that some of this scientific testimony is not so reliable, and there are subjective judgment calls that these experts have to make. And here, I don't find that to be reliable enough for the expert to make that kind of a statement. Isn't that correct?
That is what Judge Draghi ruled, correct?
Then why would you need an expert?
Because the expert still put before the jury the analysis that he conducted. Judge Draghi said the expert can testify about the analysis and about the similar markings he found. We wouldn't even be able to put the imagery of the two casings before a jury without that expert who conducted that tool mark analysis.
But
And-
because he could not say there was a match, the defense couldn't go into the fact that there was a lot of new evidence to indicate that these conclusions made by experts are not reliable. That was
What they-
eliminated from the trial, wasn't it?
The defense was not prohibited from attacking Butel, the tool mark examiner, and they did, with statements along the lines of, you cannot testify that they're a match, can you? Butel his hands were tied by the trial court from arguing that, even though his conclusions brought him to that place. But he did not testify to as much.
Given all that, how does it make any sense for the prosecutor to ask the defendant's grandmother, were you aware that the shell casings at the crime scene had the same markings as the one at EJ's house? Did you know that? How does that was there any foundation that she knew anything about the casings or the evidence in the case or anything?
That was the question posed to her, was she aware of that evidence? There's not testimony.
And there wasn't, and there is, and nowhere in this case was there evidence that those were the same markings, right?
Correct.
That's like asking a witness, did you know there were 3 eyewitnesses to the killing when there weren't 3 eyewitnesses to the killing? That was a statement based without evidence, right?
It was not a statement based without evidence. It was a statement based upon Butel's testimony and the
Butel hadn't testified yet. This wasn't in front of the jury. This was an early witness, the grandmother. How does it make any sense to ask the grandmother that question?
Because the grandmother's credibility and bias was on the line. It was before the jury. Her bias toward her grandson and her going to bat for him about him being home that night when she was apparently asleep.
This has to do with matched casings, sir. And doesn't every lawyer have the obligation to have a good faith basis for any question they ask?
The question was posed to her as to whether or not she was aware that those casings had the similar markings.
No, have the same markings. That's the question here. You've got to stick to, you can't recharacterize this. And I'm animated about this because as much as I worry about the preservation on this question, this seems to tip the hand of the state of trying to bootleg something they weren't allowed to say because it doesn't make any sense to ask this witness that question. To me.
Understood.
And the statement and the question that's asked is something that never came into evidence because no one testified these were the same markings, right?
That's true. No one testified they were the same markings. A jury can make that reasonable inference, though. If the state was not going to be asking the jury to find that those 2 bullets were shot through the same gun, there would be no reason to put in any of the ballistics evidence at all. The reason it was put in was because the imagery shows that they have similar markings. And that evidence was before this jury. The imagery of the casings was before the jury, State's Exhibit 364. And the state put that into evidence because it allows a reasonable jury to conclude for themselves that those casings were fired.
You compared this to DNA evidence earlier. Would that hold true for DNA evidence?
I think it would.
So the state could just put in front of the jury the profiles and say, look, they look similar without any testimony that they are a match within 1 in 1 trillion. Or, I mean, no jury has a clue what a DNA profile even looks like.
True. And that's why DNA analysts testify at length about their process.
I understand that, but I'm
testify.
drawing a comparison, as you did, between those slides, which I'm going to presume an ordinary juror doesn't look at shell casing markings, doesn't know how to interpret those images. And without the expert testimony, how is that any different from a jury just looking at two DNA profiles and saying, oh, well, they look similar enough?
Because when the DNA analyst testifies, much like the toolmark examiner testified, they testify about their analysis, about how they conduct the analysis, how they go through the scientific process. Judge Tregi allowed that testimony, and that
So
testimony.
what was the testimony? Can you pinpoint for me, for the court, the testimony that you believe most strongly supports the inference that these were a match?
Yes, at length, Jason Butel testified that they shared the same markings, similar markings, both on the side of the casings and on where the firing pin impression was left. And he didn't just testify that they had similar markings. He put the imagery up before the jury and testified for hours about this process, about how he conducted the analysis. And also, he testified about casings that were fired through other guns, and he compared those. And he testified about how, look at these other ones, they're not even close, and this is why. Look at the firing pin impression, look at the breech face, look at all these different aspects of the casing, and you'll see that they don't share any similarities at all. But when you look at the casing from this scene and the casing fired from Mr. Wash's gun, you see similarities across the board. You see them across the side, you see them with the firing pin impression, and so on.
Okay, so all that testimony came in to the jury.
Absolutely, it did, at length, much like it does in a DNA analyst's testimony.
Let me, there's a little bit of apology that goes with this question, but to let the lawyers know, this record on appeal, in my view, was the worst I've ever seen sitting up here in 15 years. Doesn't have anything to do with the lawyers. But it's hard to put things together. So that's why I'm asking this question. The testimony about the U-Haul going by Chang's liquor store. In the video that's with that, do I understand correctly? Because I couldn't quite figure this out. Do I understand correctly that the camera angle is trying to capture the reflection on the glass of a van behind the camera, I guess? Is that right?
That's how I interpret it as well.
Okay.
Yes.
So was only the video was shown to the jury, or were there still photographs of the video there?
I cannot tell you that at this moment.
Okay. We'll dig that out. I just couldn't figure that part out. And I think it's, and when the detective says, I can look at the glass and, I think it's the same U-Haul. I don't know quite what to do with that in terms of, juries decide things, but.
Understood.
But I wasn't sure about the evidence there.
Understood.
Can you move over to harmlessness? Because I think you should.
Absolutely. In terms of the statements about ballistics, the harmlessness comes from the fact that the defense was able to argue at length, as they did, that the state's witness, the state's expert, could not testify there was a match. You did not hear from the state's expert that these two casings were a match, that they came from the same gun. You did not hear that from the evidence. You may have heard argument from the state, but argument is not evidence, as even the district attorney told the jury at the outset of his closing argument. Arguments are not evidence. If anything I say is not supported by the evidence, you are to disregard it. The jury was instructed as much from the court, and the jury was told as much by the state in argument. And so the harmlessness comes from the fact that both sides argued at length their positions about the value of the ballistics evidence. And the jury knew that the ballistics evidence was hotly contested and that there were disagreements there. And so to the extent that the state's questions of a couple of witnesses about whether or not they saw the same markings in the imagery was error, it was absolutely harmless because the jury knew there was no agreement on the markings or on the casings coming from the same gun. When
Excuse
I
me,
stepped up,
can I, so part of this harmlessness argument, I'm still trying, I have to grasp the weight from the state's perspective of this expert opinion testimony. And as I understood it, if you sort of were summarizing from your perspective, the entirety of that opinion testimony, the witness examined several firearms, including those of potential suspects that they were exploring during the investigation, and then examined the cartridges at both locations. And it comes down to these individual class characteristics, which, as I understand that, means these are sort of markings that you will find that are sort of they don't occur because of a manufacturing process or not typically found in the class of weapons. Is that fair to say?
It's fair to say, and those markings that are left on casings are left by the gun that fired the casing. They're not manufacturing defects or manufacturing markings on the casing. They're markings that are put on the casing when the casing travels through the barrel of the firearm.
Okay.
And so there are all these different classes of those characteristics. There are the classes of where the firing pin made an impact on the casing. There are the striations on the side and so on. Buttel would probably cringe at my short circuiting of this, but there's those different classes that he testified to about where the similarities are and where they aren't.
And there was no testimony in the record that really sort of would quantify sort of the number of weapons that could potentially share those individual class characteristics, or was there?
There was not, to my understanding, and I believe some of that was prohibited. The witness was prohibited from stating to a degree of scientific certainty, much the way the state can never present evidence about DUI, a breath test giving a certain degree of certainty that they were impaired and so on.
Could you complete your answer to Justice Wiles' question? I think you'd gotten through the ballistics harmlessness, but maybe not finished your answer. If not, I'd give you time to do that because I think the court will be interested.
I believe I summarized as best I was in a position to the harmlessness for the portion that Justice Biles asked about.
The I know statements, do you want to address harmlessness on those?
On which portion?
The I know.
Yeah, the statements at the outset. When this court undertakes a methodical deconstruction of a closing argument, word for word, months later, with the benefit of the transcript, the state appreciates the fact that we have certain confines, certain rules that the state is required to follow. But when we spend such a methodical breakdown through a transcript as we do at this stage, what we end up doing is we end up diminishing and disrespecting the role of the jury in this case. If you could go back to this jury and ask them at the conclusion of their verdict what they thought the state's argument was and what statements the state made, I would imagine it was largely lost on most of them that the district attorney used the phrase "we know" a few times in transition. He used it several times referring to evidence that was uncontested. But to the extent that he used that statement on contested issues, that statement is not read by a reasonable, regular person as being that the speaker's intent to argue to that person that we all accept and we know, and you must accept it as well, because I'm saying it, because I'm the district attorney. To the extent that people on the jury may have voted for the district attorney, as my opponent mentioned, based upon the last election results, at least half of those jurors probably voted against him as well. With all due respect to District Attorney Howe, this jury did not convict Mr. Wash based upon a few errant transition statements made in closing argument. They did not place that kind of weight on the district attorney.
Well,
they convicted Mr. Wash based on a mountain of evidence. They convicted him on the surveillance video, on his lies to police, on his admitted lies to police, on his angry urging that his girlfriend get an abortion, to abort that baby. Opposing counsel came up here and said that he was convicted of capital murder for killing Ashley Harlan. He was convicted of capital murder because 7 years ago tonight, he killed Ashley Harlan and her unborn child. That's what happened 7 years ago tonight. The mountain of evidence is what convicted him, not the district attorney's argument. The surveillance images of the U-Haul he never mentioned to police.
Interrupt real quick, but if we, isn't the case law clear here from this court that we know statements aren't just errant statements that should be disregarded? I mean, it seems like you're asking us to overturn our precedent.
I did not explicitly ask you to overturn the precedent in my brief, so I'm not in a position to do so from the podium today.
Okay.
But what I am in a position to do is argue not to overturn precedent, but to urge this court, the test when analyzing such statements from a district attorney should not be taking a we know in isolation against 16 days of a trial. The test should be, what was the intent of the speaker there? It's obvious the intent of the speaker there was not to urge a jury, take my word for it. I'm the elected district attorney of the largest county in the state. You all know me. Maybe you saw my signs. Take my word for it. He's guilty. He did it. That's not what the intent was. This
So it
court
should
should
be, so
examine.
you're saying that we, instead of following our precedent, we should look to the intent of the prosecutor?
Not solely, but it should be part of it. It should be part of it when
Okay.
because when you look at the totality of the argument, what you can see is the totality of the argument was urging the jury to review the evidence that was admitted in this case, the hundreds of exhibits.
But if that
15
might have been the intent, but shouldn't we look at the impact on the jury?
And that's part two of what I've jotted down here in my notes, is that this court should examine both the intent of the speaker and the reasonable interpretation, how it would be received by a reasonable person on a jury. A reasonable lay
Which we've
person.
already decided in our previous cases. And so you're asking us to add an extra step of intent.
I'm not asking you to add an extra step, but I'm asking, when you examine the wide latitude afforded a prosecutor in arguing their case, in advocating their position, in the only portion of the trial they're permitted to do so, that they be given the wide latitude such that they could draw such reasonable inferences like the ballistics evidence inferences were drawn here. This district attorney urged the jury to draw the inference. He even said as much. He even used that word. He said, you can look at the evidence. You, Mr. Butel, may not have been able
He
to
also
testify about a
said,
match.
we know about uncontested facts.
He did. He absolutely did. And to the extent that this court finds that in isolation to be error, the state understands as much, but it was absolutely harmless in this case, taken in totality of 15 days of evidence piled up in this case that convicted Mr. Wash. He was
So when we
convicted
look at
because he-
harmlessness, we should also look at intent of the prosecutor?
you should look at the totality of the circumstances. That's what this court's precedent already says. Is
But I
that
mean, it's a two-part test.
it is
First, whether there was error,
correct.
okay? And so I understand you to saying that when we're looking at whether it was error, we should look at intent. But I don't understand how on the second half of the test with regard to prejudice, how that, why we should consider the prosecutor's intent.
That's probably not as heavily weighted in the harmlessness analysis, but you should absolutely look at how it would be received by a reasonable person on a jury, how the argument would be received.
Right.
That would go to harmlessness. And I urge this court to consider how a regular lay person on a jury is going to receive the arguments that were made in this case.
No,
Wash
this argument is about the prosecutor putting his finger on the scale. It is, and to the extent that you suggest it, we should think about intent. Respectfully, how long has the prosecutor been prosecuting? And how many times has this court said, we know is error?
This court has said as much for quite some time. I'm not disputing that. I'm not disputing how long he's been the district attorney. I would dispute that the test should be different based upon how long somebody has been an attorney, much like we say that the rules are not different for a rookie police officer as for a veteran. The rules are the same for everybody across the board, whether they're elected, whether they're a line ADA, whether they just started, whether they've been doing it for 30 years. The state understands this court's precedent and recognizes as much. But in the totality of the circumstances, when Mr. Wash sat in a police interview and lied through his teeth for 7.5 hours, and he told the jury he lied to police, he lied to them about ever buying a gun, he sold the gun on the street before he was arrested because he didn't want the police to know that he had a gun. He lied to his other girlfriends that he had at the time. He lied to his employer about coming and going from work to commit to do these things. He never spoke about a U-Haul. He piled on the lies and he admitted that he lied in all those fronts because he did not want the police to catch on to him. He did not want police to be on
So,
him.
counsel, I'm going to just interrupt because I know you're out of time, but I do want to get a couple more questions because I'm a little confused about this last part of the argument about what your position is on the error prong. I understand when we move to harmlessness, it's very common for a harmlessness analysis to consider the weight of the evidence. And that's the bulk of what you're saying.
Correct.
But I just want to ask you directly, is the state conceding that, and there were many, many instances of we know statements that, for example, we know the defendant killed Ashley Harlan. Many instances of we know followed by contested, something that was contested. Are you conceding that those were error?
Under this court's precedent, they were.
Okay.
On the, your request that we consider the prosecutor's intent, I mean, we did away with that in Sherman, right?
You didn't entirely do away with it. And to the extent that opposing counsel was just up here arguing, instead of prosecutorial error, she used the word misconduct. And she spoke about the intent and how deliberate it appeared to her. To the extent that this court considers intent, it usually does so in the context of misconduct, the step beyond error.
Right. But
And
we're
so-
only talking about error right now, so,
Because opposing counsel was up here using misconduct as the framing,
okay. I mean,
the state wanted to respond.
and well, I'm an old lawyer and I still slip on misconduct. And Sherman
And we still slip with we know.
yeah, I mean, you know, and Sherman also said that even a strong case, and I'm not saying this was strong, but even a strong case can have prejudice that requires reversal, right?
Correct. Overwhelming evidence is not a trump card. It will not always invalidate claims of prosecutorial error.
This is entirely a circumstantial case. You have no direct evidence of this defendant killing the victim, right?
Correct.
So, I mean, in that respect, to me, this case is a lot like Chandler, where, you know, the state spends weeks putting on all kinds of facts and evidence and witnesses and all that, and then tells the jury, hey, you see this haystack over there? Well, I know there's a needle in there, and here it is. And we know that this needle is in there. So that's what we're trying to sort through. This is a complicated case in terms of how much stuff there is, made more difficult by the way the record is set up. But you're not asking us to overrule any of our precedent, is that right?
I'm not.
Okay. And
In
you
the
did not appeal Judge Dragi's order on the limitation on your expert.
No, because the pretrial order only limited the expert's testimony. Opposing counsel repeatedly has briefed and argued before this podium that the pretrial ruling prohibited the state from arguing certain facts and arguing certain positions or inferences. And that's simply not the case. If this court looks back to the pretrial ruling was very specific. And if we're going to be talking about nitpicking transcripts and going word for word, that's what lawyers do. That's what the district attorney did here. Both of the attorneys that prosecuted this case did. And they went through that pretrial order. They asked for clarification from the trial court, and they asked the trial court, but the witness can talk about these things and not those things. Yes, yes, yes.
So is it your position that the pretrial order prohibited the expert from saying things? It did not prohibit the state from asking other witnesses to testify to the prohibited topics.
Precisely. Because the markings were put up there. The imagery was put up on a projector for everybody to see.
We're making any other witness that testified in the case a tool making expert.
We're absolutely not making them an expert, but we're saying, you looked at those. Do you see the same markings on that?
So that
It's the same thing we're asking a jury to do.
Stiegel's question, we could put up 2 DNA profiles to lay witnesses and say, hey, those look the same, don't they?
The question could be posed. I don't know why it couldn't be. And
Why, it asked for an opinion.
I'm sorry,
It asked for an opinion.
it
So how
does.
do you lay the foundation for that?
You looked at the imagery. The imagery is before you. Do they, much like we say, look at the surveillance image, look at the grainy surveillance image through a reflected pane of glass. Do you see the same truck there? The state is asking the jury to conclude that's the U-Haul with the errant graphic on the fender, one of one that had an errant graphic on the fender that Devonte Wash checked out that day. That's the truck. The state's asking a jury to say, we don't have an image expert. We didn't have a video surveillance expert testify and do it like they do on TV where they clarify it and enhance it so that it's crystal clear. We never do that. We can't. But what we can do is we can put the imagery before the jury and say, you can look at that. You can make the reasonable inference that that's the truck that Mr. Wash checked out that day. Much like you can look at the tool marks on the casings and you can conclude that they were fired from the same gun. You can conclude that that DNA found in that place was from that person. You can conclude as much, even though the expert never testified there was a match, that the expert did testify that there's 1 in 9,000,000 chance that a random person would have contributed the sample. That witness will never testify about a match. They never do. But that does not prohibit the state from arguing to a jury that the reasonable inference can be made that the imagery shows the truck, that the DNA was a match, that these 2 casings were fired from the same gun. In recognizing I'm out of time, I appreciate the court's indulgence. If the court has any further questions, I will remain for them. But I would ask that this court affirm Mr. Wash's conviction and sentence.
See no questions. Thank you.
Thank you.
Ms. Stratton, you reserve 3 minutes.
Thank you. I don't believe I have much to say on rebuttal, except for to emphasize that the state is arguing that the trial court interpreted its own order incorrectly. Because the trial court, when the defense objected, when it asked a layperson to say that the markings were the same, when it asked the jury to make the inference in closing arguments that the markings were the same, there was an objection that was sustained.
Can I ask a quick question about that? For the purpose of my question, let's set aside everything the prosecutor said. Just assume it didn't happen. In your view, was the admissible testimony of the markings expert, along with the slides that were talked about of the casings, was that evidence sufficient to allow a reasonable juror to conclude that the casings came from the same gun?
No,
And why not?
because that was the trial court's order. That is what.
No, I'm not talking about the trial court's order. I'm talking about a jury. Like if you were challenging that on the sufficiency ground, how would you argue that that evidence, which properly came in, you're not objecting to what the expert testified to, and you're not objecting to the photographs, the slides, would that evidence be sufficient for a jury to conclude that they came from the same gun? And if not, why not?
I don't believe so, because.
Why not?
Because the science will allow us to get so far. It will allow us to get to the same. Beyond that, there's no evidence in a trial to give a jury a basis to make a reasonable inference. The point is that,
The
yes,
testimony about the similarities is not sufficient to allow a jury to come to that conclusion.
to make a reasonable inference that they are the same. Yes,
So that would require expert testimony, is what you're saying.
I believe so, yes.
Because it's an opinion that requires expertise.
Because having viewed, I keep going back to the trial court's order, and I know you asked me not to. Having viewed all the evidence about what the science can tell us in 2025, I mean, and all expert testimony is opinion. I'm trying to work my way through your question. It's as if there was an affirmative, the science can get us this far, and it affirmatively cannot get us any farther. That is what the trial court determined after viewing all this evidence.
Was there anything, any evidence as to comparing the hundreds of thousands of other guns out there as far as the likelihood that something would be this similar without saying same or match?
I don't remember any such testimony.
The expert's testimony was still relevant to identity. Would you agree?
I would agree, yes. the way I view it is it's almost, the expert sort of says you can't exclude them from being the same. That's about as far as the expert could go. They're similar. We can't say they're not the same, but we can't say they're the same.
And it's a question of degree then, how similar. And that testimony that at microscopic levels, the weapon has these markings that aren't caused by a manufacturing process, but through unique characteristics of the gun itself, is creating these types of marks that appear to be generally consistent between two sets of cartridges. Is that a fair summary of the testimony?
I'm sorry, I can't say. I'm not sure I completely followed. It's a very confusing body of science. I'm sorry, I just can't say. And I guess I would just, my final point is that the reason that I think I'm very not articulate about this issue, and in defense of opposing counsel, the trial court's order was not appealed. Whether the trial court was right or wrong, and its Daubert decision was not appealed. So that's why we might not be as articulate as we otherwise would be. Thank you.
Thank you to both counsel. The court will take this matter under advisement.